Welcome, everybody. Welcome to today's Law of Self-Defense show on a lovely Monday with fire trucks screaming down the street in front of my office. That's why we're delayed a little bit. Figured we'd start the show without the siren effect. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. And today we are gathered because of news reports and the release of a 911 recording is what really popped this event back into the news. But it involves a shooting in South Carolina. Homeowners on 911, gun in hand, as someone tries to kick in their front door. And they fire a shot through the door and strike and kill the person on the other side. Is that lawful to do that? And we'll explore some of the facts that would be relevant to answering that legal question. So we'll get into that. We'll play the 911 recording. We'll share additional facts and context that were learned after the shooting that the homeowners were not aware of. And then I have a couple of little bonus pieces as well for today's show because these are things I wanted to touch on. Where are they? But they didn't seem like they were substantive enough for an entire show all by themselves. So this is live streaming on YouTube, Twitter, Rumble. I sure hope it's streaming. Yes, it is. And of course, to our Law of Self-Defense members on the Law of Self-Defense dashboard. And as always, when we get to the Q&A section of today's show, we will cut the YouTube, Twitter, and Rumble streams, and we will continue streaming only for Law of Self-Defense members. That's when I address questions and comments from the membership. I'm also going to go quickly through a couple of other news stories. One is this one. It involves a robbery in Portland, Oregon, of a vape shop in which the robber claims to have a gun, but apparently doesn't, or at least he never shows the gun. And the clerk responds with an actual gun of his own that he does display, as we see here. So can you pull a gun on someone simply because they're telling you they have a gun? We'll explore that question. And the second one is a disparity of numbers video that just came across my desk from Twitter, where somebody's getting beat up by a group of people. They all appear to be unarmed. Had this victim at the beating had a gun, would he have been legally privileged to use a gun against people who were only attacking him without a weapon? Or would that be a disproportional defensive response that would lose him self-defense and put him in prison for the rest of his life? So we'll explore those two. But those two, the disparity numbers in the vape shop, I'm only going to touch upon after we end the public streams and we're in the members only portion of the show. The good news is you can become a Law of Self-Defense member right now. It's dirt cheap for 99 cents, folks. 99 cents gets you a 2-week trial membership. You get access to all this members-only content and privileges. You get PDF transcripts of every show and so forth. You can get that for 99 cents. Now, after the 2-week trial, if you stay a member, and really everybody does, it's still dirt cheap, folks. It's only 30 cents a day, about 30 cents, less than $10 a month to be a Law of Self-Defense member at lawofselfdefense.com/trial. At least try out the 2-week membership for 99 cents, lawofselfdefense.com/trial. If you do that right now, you'll be emailed directions for how to join us for the remainder of today's show when we go members only, lawofselfdefense.com/trial. All right, with all that said, now that you have an overview of what we'll be doing today, I'll go ahead and, of course, I forgot to load up the little start of show clip, but it's loading up right now. 3, 2, 1, here we go. And, of course, today's show is brought to you, by none other than Law of Self-Defense itself in the form of our best-selling book, Law of Self-Defense Principles, your handbook to being hard to convict if you're ever compelled to defend yourself, your family, your property from criminal predation. Check it out on Amazon, 5-star rated, bestseller in its category, but don't buy it on Amazon. They'll charge you for the book. I think it's $20 or $25, plus shipping and handling. We ask only that you cover the cost of shipping the book to you. We'll eat the cost of the book when you order it from us at lawofselfdefense.com/free. free book. Hard to beat free, folks. lawofselfdefense.com/free book. All right. So the first thing I'm going to do is play the 911 recording for you. This is from the apparent home invasion in South Carolina. It's a couple in the home. The woman is on the phone with 911. The male goes and retrieves a firearm. And that's about a 3-minute 911 recording. And the woman's reporting that someone is smashing in their door, effectively, that they're dealing with a home invasion. And the law enforcement dispatcher on the other end, that's how he reports it out to responding police officers. And I want to play this first before we dig into the additional context, because this is what the homeowners had to work with at the moment they made the decision to fire that shot. So let me pull this up. And by the way, I want to point out as well, listen to the emotional tenor of the woman on the phone with 911. It's hard to miss. All right, here we go.
Today, August 26, 2023, 01:54 and 05 seconds.
It's 2 a.m.
911, where's your emergency, please?
Hi, somebody's trying to break into our house.
What's your address?
They're trying to break in the front door. They're banging on it. Yes.
Okay, they don't live there, do they?
No, nobody else lives here. They just broke the window. Oh, my boyfriend just shot through the door.
You what?
My boyfriend just shot through the door.
With a gun?
Yes. They just broke through the door and my boyfriend shot.
Holy shit, I think I got it.
Please get here fast.
Holy shit. You know if he
Hello?
hit the subject or not?
He said he thinks he hit him.
All right, we got shots fired on this home invasion. Fucking family member. Holy
I'm just freaking out.
Okay, y'all say they broke the door. Did they get in?
No, they didn't break in, but they broke our door has glass on the top, and they broke the glass panel.
Break into my fucking house.
Well, yeah, we should stay inside till the cops get here, right?
Yes, ma'am.
Okay.
Is there any way you can peek out without anybody seeing you to see if is anybody laying on the porch or anything?
No, it's the glass is like frosted. I have a camera. Hang on.
That's a ring camera.
He's asking if we can see if there's anybody out there.
Doorbell camera.
I'm just freaking out. Well, I can't see. No.
Oh, thank God.
It doesn't look like there's anybody on the camera, but I can't tell. It doesn't show like right in front of the door, so I can't tell all the way up, but I don't see anybody in the view that it does have. There's somebody out there? He said there was somebody out there. He saw him.
The cops?
No, my boyfriend.
Is a subject laying down? Is it male or female? Can you tell?
Is it a male or female? Is he laying down? It's a man and he's on the ground. Okay, I think the police are here. I know. Oh my God. I know he was trying to break in.
All right, ma'am. The police are going to make contact with you. They're outside, all right?
Okay, thank you.
All right, you're welcome.
Okay, so that's the end of the 911 call. Couple things, right? One is you can hear the stress, obviously, in the woman's voice, right? I see someone in the comments suggesting she's not doing well on the call. She's just normal. I mean, that's how normal people respond to these events of violence when they're on a 911 call. It's not particularly relevant in this case, but because I think it's fairly well, as we'll see, we'll look at South Carolina law on defense of highly defensible property. They have a very robust justification argument here based on what they knew reasonably under the circumstances. And the lights just went on in my office for some reason. But if it were a sketchier legal justification, and the police were interrogating this woman immediately after this event, you think she's in a proper mental state to be interrogated by the police in terms of her legal defense? I would suggest no. All right, hold on a second, folks. I've got to turn this light off. Nothing but the highest production value. No, we have these motion detected lights. I've got it taped over, so it won't trigger, but for some reason it just decided to go on. Another thing to note is the dispatchers on the phone will often ask the caller to do things that are imprudent, right? Can you look outside and see what you can see without the other person seeing you? I mean, of course, the dispatcher wants more information, wants as much information as possible so he can pass it on to the responding officers. But it can lead the person on the call to do things that are unsafe. I personally once was driving down the road in my old town in Massachusetts where I used to live, going by the bowling alley, and there was a couple dudes grabbed somebody out of a car and started beating them up in the parking lot. So I pulled into the far end of the parking lot, maybe 80, 100 yards away, where I could see what was going on. And I called the local PD, which the police station was like 2 blocks down the road. And I said, hey, you might want to send someone down to the bowling alley because some dude's getting beat up. And he got pulled out of his car. And the dispatcher says, well, can you see, the license plate of the car? I said, no, not from this angle. She said, can you get closer? Now I'm carrying a gun on my person, and she wants me to get closer to a fight in progress. I said, no, ma'am, I can't do that. But of course, that's not going to keep them from asking. So just because they're asking, don't treat it like some kind of order. Dispatchers don't give lawful orders over the phone. They're trained not to do that because, of course, they don't know what's actually going on because they're not present. And of course, this recording becomes evidence. Now, they had a Ring doorbell. I'll play you a little clip of the recording from the Ring doorbell in a moment. That also is evidence. And people often ask me, well, should I have cameras? Should I have a dash cam? Should I be recording stuff? And the answer is always, well, it's helpful to record stuff that's helpful. So if you're doing things right, yes, having the recording is helpful. Because where good guy cases of self-defense tend to get into trouble is not when there's too much evidence in the case. It tends to be when there's too little evidence in the case and your claim of self-defense begins to look fabricated or speculative or unreasonable, and a prosecutor is led to believe that he can successfully attack that claim of self-defense. So good guy cases of self-defense, you generally want more evidence. But if you did it wrong and that's recorded, that's evidence against your claim of self-defense. So you might want to make sure you know what to do right. So whatever recording is made, and by the way, even if you don't have cameras, there's cameras everywhere. Everyone has a camera in their pocket. Your neighbors have Ring doorbells too. So just assume you're always being recorded. So these people are dealing with what they believe is a home invasion. When they describe what's happening to the dispatcher, that's how he characterizes it, as a home invasion. They fire a shot through the door. First of all, can you fire a shot through the door? Can that be lawful? Well, the real question is, and you might think, well, you're firing blindly then. But are you really? So the real question is, are you using defensive force in a negligent manner, in a reckless manner, because you're using a gun? And that could be true if you're firing through a door. You hear a knock on the door and you fire through the door. What was that? And of course, if you miss whatever the threat is, then you're sending a round through your community, right across the street into your neighbor's house. But are there circumstances in which you have a reasonable idea of where the apparent threat is, where the reasonably perceived threat is? So, for example, there's a glass panel in front of your door and you can see the top of someone's head. Well, they're probably standing right in front of the door. And I would argue that's a shot that could be taken in a non-negligent manner, if, of course, the other elements of self-defense were satisfied. I'm not an advocate of just blindly sending rounds through a neighborhood, but the circumstances may be such that it's not negligent conduct to shoot through your own front door, not wait for the front door to be completely kicked in, if you have reason to believe that an effort is being made to kick the door in. And here these people at 2 a.m., surely they were asleep, have someone banging vigorously on their door and then breaking the door. That's a unlawful and forcible entry into the home. That's a home invasion. At least it's reasonably perceived as a home invasion. And that's the wrinkle here. Because what we really have here is an unintentional intruder, or an innocent intruder, I should call it, an intruder without malice. What we had here was a very drunk college student who'd recently moved into a home on this street, like in the prior week, and almost certainly thought he was at the place where he was now living. And his housemates inside the home were simply not letting him in, or were asleep and weren't waking up. And he was locked out, and he didn't want to be left out there all night. And he's drunk and he's angry and he's pissed and he starts banging on the door. Ultimately bangs it hard enough to break it. But he was not there for the purpose of malice. If he'd known he was at the wrong home, if he'd managed to break in and there were strangers in there saying, "What the hell are you doing?" he wasn't going to hurt those people. He wasn't there to steal anything. Here's a little video clip from the Ring camera. Whoops. So this is what was actually happening outside the home. Presumably this is before he actually broke the glass in the home. So he got dropped off by an Uber from the bar he'd spent all night at. His friends would testify that he was extremely drunk. It's probably the doorbell.
Call Catherine.
And presumably he waited a while and just got more and more frustrated. That's it for the Ring camera call. So he banged on the door hard enough to break it. Now he's acting without malice, but is that the legal question here? Does that matter? What matters is the reasonable perceptions of the defender, given all the circumstances, what they're observing in terms of evidence, and what was known to them. So this is 2 a.m., middle of the night, dark 30, and someone is apparently breaking in their door. So what does South Carolina law have to say about that? And by the way, this kid turned out to be a perfectly nice kid, athlete at the college. Everybody liked him. Good family. But of course, that's not relevant to the legal question. So let's take a look at the relevant South Carolina law, which South Carolina calls its stand your ground law, which, you know, of course, I don't like it when they do that. Stand your ground has one meaning, that if you would have had a legal duty to retreat defending yourself outside your home, you're relieved of that legal duty to retreat if you're defending yourself inside your home and its curtilage, the area immediately around the home that's part of your day-to-day use of the home. This does a lot more than just that. It does do that. It relieves you of a otherwise existing legal duty to retreat, but it does much more. It provides legal presumptions about both the defender's mental state, and it provides a legal presumption about the apparent invader's mental state. So this is what I refer to as a defense of highly defensible property statute. So we differentiate defensive property between personal property, tangible items, open, unimproved land, that's least defensible property. Highly defensible property is stuff like your home, any dwelling that you're staying in, a business, an occupied vehicle. So, and that's how South Carolina defines it, as we see here in the title. Presumption of reasonable fear of imminent peril when using deadly force against another unlawfully entering a residence, occupied vehicle, or place of business. So this is defining the scope of highly defensible property under South Carolina law. And one of the things they do to give you greater discretion in the use of deadly defensive force when defending yourself in the context of highly defensible property is they create a presumption of reasonable fear of imminent peril, specifically in this first paragraph A here. So first they set out the conditions that have to be met to qualify for this legal presumption. It's legally presumed you had a reasonable fear of peril. Then in paragraph B, we'll see that they also set forth a bunch of exclusions. So even if you would qualify under these conditions, you lose that presumption if you trigger any of the exclusions. Now, that doesn't mean you lose the privilege of self-defense. Generally, it just means you would lose this legal presumption of reasonable fear. So let's step through it. And by the way, many states have these kinds of provisions for defense of highly defensible property. This one from South Carolina is highly representative of the general framework. A person is presumed, meaning legally presumed, to have a reasonable fear of imminent peril of death or great bodily harm, great bodily injury to himself or another when using deadly force that is intended or likely to cause death or great bodily injury to another person when, and before we get to the when, let's think about what this is giving us here, right? To be justified in the use of deadly defensive force against another person, you have to, of course, satisfy the elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. And if we look at this, it's basically giving us most of those elements. So innocence is kind of baked into the cake if you're in your home and somebody's breaking in, which we'll see is one of the conditions. Imminence is specified here. It's legally presumed that the peril is imminent. Proportionality is legally presumed that you're facing a threat of death or great bodily injury, not merely a non-deadly force threat. So if it was only a non-deadly force threat, you could only use non-deadly force in self-defense, but it's presuming that you're facing a deadly force threat against which deadly defensive force would be appropriate. Avoidance element is going to be excused under the proper definition of Castle Doctrine anyway, but the statute also addresses that in a later paragraph. And it's presumed that all this is reasonable, which of course is the fifth element of self-defense. So this statute is giving you 4 of the 5 elements of self-defense, everything explicitly except for innocence. And innocence, again, is baked into the cake. That's pretty good stuff in terms of the strength of your claim of self-defense and the difficulty that the prosecution would have in attacking any one of these now legally presumed elements. So you're presumed to have that reasonable fear of imminent death or great bodily injury if, and here are the conditions, if the person against whom the deadly force is used, the deadly defensive force, is in the process of unlawfully and forcefully entering, or has unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if there's a kidnapping attempt, is a second criteria here. And you, the person using the deadly force, knows or has reason to believe an unlawful and forcible entry is taking place. So you can't just discover after the fact that there was an unlawful and forcible entry. You have to know it in the moment when you're making the decision to use deadly defensive force. So do you have to wait until the person has unlawfully and forcefully entered? No. This legal presumption is triggered if they are in the process of unlawfully and forcefully entering. And that was certainly the case here when the door is physically broken. Now, might it be different if they were only banging hard or even kicking the door? Could it be more ambiguous whether a forcible entry was being attempted or whether they were just banging on the door to make a lot of noise to get the attention of people inside and had no intention of kicking it in? I mean, if there's not actually physical damage to the door consistent with a attempted forcible entering, might a prosecutor argue that, well, there wasn't enough evidence here of forcible entering to trigger this legal presumption? Yes, but if something is in fact physically broken, does that ambiguity go away? Sure, it sure does. So if you meet these conditions, they were in the process of unlawfully and forcibly entering, and you knew that at the time, well, then you're you are legally presumed to have had a reasonable fear of imminent deadly force harm at the hands of that intruder. So those are the conditions that have to be satisfied. What are the exclusions? The exclusions are pretty common as well. You don't get the benefit of this legal presumption if the person against whom you use the force is also a lawful resident. So if it's a co-dweller, you don't get the benefit of this legal presumption. Does that mean you can't defend yourself against a co-dweller? No, you have all the normal standard self-defense available to you, but you don't have the benefit of this legal presumption. If it's a kidnapping scenario, one of the exclusions is that the person doing the kidnapping has legal custody of the person being taken. Well, then it's not really a kidnapping, right? Another exclusion is that the person who's using deadly force is engaged in unlawful activity using the dwelling. So if it's if you're selling drugs out of the house, you still have a right to defend yourself against violent attack, but you wouldn't get the benefit of this legal presumption of a reasonable fear of imminent deadly force harm. And the last one, also very common. The person against whom the deadly force is used is a law enforcement officer who enters or attempts to enter the dwelling in the performance of his duties, and he identifies himself, or the person using force knows or reasonably should have known that the person entering is a law enforcement officer. And here in paragraph C, we get to the addressing the element of avoidance, whether or not there's a legal duty to retreat in this context. A person who's not engaged in an unlawful activity and who is attacked in another place where he has a right to be, including but not limited to his place of business and, of course, your home, has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he reasonably believes it necessary to prevent death or great bodily injury to himself or another person, or to prevent the commission of a violent crime as defined in another statute. So that would be typically enumerated forcible felonies. So that first presumption here in A is a presumption about the defender's state of mind, right? Their mental state. It's legally presumed that the defender had a reasonable fear of imminent deadly force harm. This statute, and again, this is fairly common, also has a legal presumption about the mental state of the person breaking in. We see that here in paragraph D. A person who unlawfully and by force enters or attempts to enter a person's dwelling, residence, or occupied vehicle is presumed to be doing so with the intent to commit an unlawful act involving force or a violent crime, again, as defined in that forcible felony statute. And a person who by force enters or attempts to enter a dwelling, residence, or occupied vehicle in violation of an order of protection is also presumed to be doing so with the intent to commit an unlawful act, regardless of whether or not they are a co-resident of the dwelling. Because, of course, if they're under an order of protection, they're not really a resident anymore, right? The law said you're not privileged to enter that property. So I can tell you that very quickly, the authorities within days had announced that they were not going to be charging these homeowners for the shooting. Everybody felt terrible that this young kid died over what was in effect a misunderstanding, but it was a misunderstanding that created a reasonable perception of him being a home invader, including the breaking of the door, particularly the breaking of the door. Now, why do these statutes typically require, not always, but they typically require both an unlawful and a forcible entry? Because of the concern of the innocent intruder, someone who's there unlawfully, but without malice. And if this window had not been broken, that probably would be the scenario here, because we wouldn't have the evidence of the forcible entering. We don't only have an attempted unlawful entering. And of course, it is unlawful because this college kid does not have privilege to enter this home. He thinks he does, but in fact, he doesn't. So he's attempting an unlawful entry. But there are many circumstances in which an innocent intruder can be unlawfully present, but not with malice. For example, a repairman sent to the wrong address, right? Dishwasher repairman is told, hey, these homeowners need their dishwasher repaired. They can't be home, but they're going to leave the back door unlocked so you can get in and do the repair. And then they give the repairman the wrong address. And he goes to the wrong house. And sure enough, the back door is unlocked and he walks in. He's unlawfully present. He doesn't have privilege to be in the wrong house. But is he there for purposes of malice? To do harm? No. And so the law doesn't want to give the homeowner the benefit of this legal presumption in that scenario. But while there can be an innocent explanation for why someone is simply unlawfully present, you can't really have an innocent explanation for why someone is, there go the lights again, unlawfully present and they broke something to get in. Now, of course you can. I mean, technically we do here, but once the breaking, the forcible is occurring, it's not reasonable any longer to expect a homeowner to have a lengthy discussion to try to find out what's going on in the crisis of the moment. Hold on a second, folks. Stupid ghost in the machine. So another thing we have here is we have this Ring camera. I don't know if all the models of Ring doorbell do this. I have a Ring doorbell, and it's possible for me to speak over the doorbell, to speak to someone who's outside, communicate back and forth. Could the homeowners have done that when someone's banging on the door at 2 o'clock? Maybe. It depends on how quickly things went. But are they legally required to do that? I mean, I presume they didn't even think of it. I probably wouldn't think of it. I don't know, 2 a.m., you're just woken up. Everything's happening within a 2 or 3 minute time frame. Frankly, you're doing pretty good to get your wife or girlfriend a 911, get your gun. And be prepared for someone, don't go outside. Don't act until it's apparent, reasonably perceived that someone's actually breaking in. Once that door starts breaking, it's an appropriate time to fire that shot, unless you feel that you have the luxury of waiting. That's a call only you can make. But I can tell you that you're unlikely to use the capabilities of your Ring doorbell in real time if you haven't thought about it ahead of time. And if you don't routinely make use of your Ring doorbell for that kind of purpose. Under stress, our mental bandwidth shrinks. We don't have more mental bandwidth. Under stress, we have less. So we're likely to be less creative in our thinking and focus on immediate responses to the threat. Let's see. What else? And I expect these people just never even thought. And then when they do look through the Ring doorbell camera, right, you don't see all that much. I understand they have an improved version now with a wider camera angle that really goes almost like to the bottom of your doorway. But the standard cameras are, there's a huge area here where you just, at the bottom, where you just can't see what's going on. You certainly couldn't see if there were people standing on either side of the door waiting to rush in, right? But nevertheless, generally more information is better if you can manage it effectively. All right, folks, I am going to prepare to wind up the public stream. So again, this is streaming on YouTube, Rumble, and Twitter, as well as to our Law of Self-Defense members on the members only dashboard. Well, the YouTube, Rumble, and Twitter feeds are about to end because we're about to start the Q&A portion of today's show. We're also going to cover these 2 additional use of force events, both of which were caught on video. The robber bluffing that he has a gun. This is the clerk with the gun in hand. That's the robbers on the left. Robber bluffed he had a gun. Clerk had a gun. And this disparity of numbers attack. People are attacking you with no weapons, but there's several of them. Does that justify you going to a deadly force, getting your gun out and starting to fire shots into those aggressors? We'll cover both of those as part of the members only portion of the show. The good news is it's dirt cheap to become a member. You can do it right now for 99 cents. 99 cents gets you a 2-week Law of Self-Defense trial membership, gets you access to all our members only, all of it, years of content, transcripts of shows, and much more. And it gets your questions and comments answered in the Q&A portion of each show. And if you stay a member after the 2-week trial, it's still only about 30 cents a day, less than $10 a month. You can get your 2-week trial membership for 99 cents right now at lawofselfdefense.com/trial. If you're a Law of Self-Defense member and you're watching this on the member dashboard, don't go anywhere. We're coming right back. If, however, you're not yet a Law of Self-Defense member, not in the process of becoming one right now, if you're on YouTube, Twitter, or Rumble, your feeds are going to wrap up. So don't go anywhere, members. We have about a 19-second little video, and then I'll be back with all of you.